Thank you very much, President Varga. I entirely subscribe to what you just have said, and it's in that spirit that I'm here today. Dear colleagues, dear friends, members of the Kúria, I see it really as a great privilege to have been invited to the most respected Kúria, I always say Kúria with K, of Hungary, to celebrate the 20th anniversary of the accession of Hungary to the European Union. And let it be very clear, the European Union is not complete without Hungary. Hungary is essential to the European Union, just like the European Union is essential to Hungary. And that I can say for all the member states. But especially in this part of Europe, it is a historically important part of the membership in the European Union. And so I'm very pleased that there is a real wish of convergence of Hungarian law contributing to the common legal system, which is a system of European values, principles, and rules. Now, I have been asked to to reflect a bit, and I hope thereafter also to discuss with you, and formally, informally, maybe also after this more formal setting, the principle of primacy understood in the relationship between the Court of Justice of the European Union and the national courts, in particular the national supreme courts. I was also asked to dwell upon somewhat in more detail a case which has been decided by a 5-judge chamber in January of this year, global ink trade. So I believe that the topic which President Varga asked me to deal with is rather topical, because we don't only this year celebrate the 20th anniversary of Hungary's and 9 other member states' accession to the European Union, but we also celebrate the 60th anniversary of a crucially important case, Costa against NL, which states the principle of primacy of union law over conflicting national law. And 60 years back, it was a very small community of 6 founding member states, France, Germany, Italy, and the 3 Benelux countries. Our predecessor says that the principle of primacy of community law establishes the preeminence of EU law over the law of the member states. That is the quote of the time. Let me be clear with you. I'm an academic, I'm a professor in Leuven. I've always told my students, and I say today for my judicial colleagues and friends, that I dislike the wording of the principle of primacy in these terms. There is no such a thing of preeminence of EU law as though it were a foreign body of law over national law. Preeminence, in my sort of linguistic feeling, almost indicates a normative, a moral superiority, a preeminence. There's nothing of the sort. The primacy rule is what the Germans call, or the German jurists, both in Germany, in Austria, in other German-speaking jurisdictions, Anwendungsvorrang. It's a conflict rule. When you have the common rule and you have a unilateral rule of a member state, then of course the common rule, when it is properly interpreted and when it has been adopted within the competences of the Union, the common rule should of course prevail over the unilateral rule. This is almost the expression of the public international law rule, pacta sunt servanda. You should hold through what you have committed yourself to. So for me, primacy is a conflict rule, conflicts of laws. Now, the court, and that is important of this Costa-NL judgment has justified the primacy rule not as an objective in itself, but as a means, as an instrument for a higher objective. And the high objective is something which lawyers know, and President Varga has in fact just referred to it. It is legal certainty and equality before the law. Because if you make a legislative act of the Union, let's say a regulation, or I see my good friend Peter Darak, the directive on value-added tax, which is a directive but in fact a thick code of law, a tax code, so that the taxable base be the same, the assessment of the tax, in all the member states. And that's important so that there not be distortions of commercial transactions, especially when they take place cross-border in the internal market. And then 1.4% of the revenue is an own resource to finance the union budget. So there is a very good policy reason why it be the union legislator having made these absolutely uniform rules of assessing this transaction tax, the value-added tax. Just by way of an example about among tens and tens of other possible examples. It's quite clear that to guarantee the equality of taxpayers before the law, you need a uniform understanding of union law. And if there is a conflict with a national rule, the union rule should prevail, not because it is morally superior or preeminent in whatever high-level sphere. No, simply in order to guarantee the equality of the citizens of the businesses before union law, in this example, in their capacity as taxpayers. So the primacy of union law is to be related to the equality of member states, of citizens, of businesses before union law. Consumers also. So I'm very happy with the reference of the Kúria to our court in a consumer protection case. It's the same concern. The goods are manufactured or imported in a particular member state. From there on, they go through the whole commercial chain everywhere. That is why consumers are protected in accordance with common standards, because the goods are everywhere in a single market. So it's a spin-off of the internal market, a single market. You need uniform protection of consumers. But then, consumers must be protected in the same way from Estonia till Portugal, from Ireland to Greece. And I take now the diagonals through the map of Europe and all in between. So, primacy is not a goal in itself. It's an instrument of guaranteeing legal certainty, as was said. It's an instrument guaranteeing equality before the law. Now, a very important point is this one. The court has, and it may have, I wouldn't say escaped, but it may not have been seen center stage. The court has specified the link between primacy and direct effect. Because you know, before Costa-NL, the year before, there was a tax case van Gent and Loos. I'm a Dutch speaker, so I pronounce the name in its original pronunciation. Van Gent and Loos. And in that case, a reference from a Dutch tax court, the court established the criteria for invocability of European Union law rules and the rights which for citizens these rules might create. In that case, the right not to have to pay a tax. In these days, an import tax. It was still in the transitional period. Now it's all legal history, the substance of that case. It was the standstill clause for import and export duties between member states in the transitional period, the cases of the early 60s, before the customs union existed as of 1968. So now it's all legal history. But the question was, can an undertaking, in this case, de naamloze vennootschap van Gent en Loos, is van Gent en Loos Limited, if you say it in English, as a company, can they rely on the standstill clause of the treaties? And the court says, well, the duty imposed on the member state, that is not to increase the tax burden, is so clear, precise, and can be enforced by a judge. That's what we mean by unconditional. That in fact, yes, to that obligation, to sort of stand still, corresponds the right not to see, for the taxpayer, the taxes increased. So the court there spelled out the direct effect. But what does direct effect mean? And the example, that's why I sort of recall this historical example, it shows that it is the three conditions, clear, precise, and unconditional, of the rule, to create rights which a private party can invoke as such against another party, in this case the tax administration, directly based on union law. So it is, if you want, a rule on the invocability of the rules of union law. Now, in a crucially important judgment, and that might have escaped attention, of the 24th, and I quote the date because you find all the judgments on their date in the in the digital court reports. It's a Grand Chamber judgment of the 24th of June 2019, and it goes under the name Popławski II. It's a Polish name. And there the court has specified in this Grand Chamber judgment, this is not in a tax case, it's in a case about a European arrest warrant, a framework decision, but the court makes clear that what it says about a framework decision holds true in exactly the same way for directives. And you'll see why that's crucially important, because after Lisbon Treaty, there are no longer framework decisions. All the also criminal and criminal procedural cases are now dealt with through directives. But the two are totally similar. It's the objective to be reached, and then the member states have the freedom to decide on the form and the methods of implementation. So that is why we made really a pronouncement of principle. And there it is said that the principle of primacy, our subject today, must be combined with the direct effect when it comes to the obligation of setting aside conflicting national rules. And that's important. So, when a rule of union law has direct effect, and that is an interpretation of the rule of union law, if there is doubt, by the Court of Justice of the European Union. When the court says yes, the Van Gent and Loos criteria, clear, precise, and unconditional, are fulfilled. The rule has direct effect and can be enforced as such for the rights derived by private parties from this rule. If then there is a national rule which is in conflict, the national rule must be set aside. But suppose now we have a directive. You know that directives, under vested case law of our code, have no horizontal direct effect. Why? Because a directive is something intrinsically different from a regulation. A directive is something intrinsically different from a regulation. Regulations are directly applicable, general application. It's like a national law, they operate as such, have always direct effect. The directive, on the contrary, is creating an obligation for the states to implement it. The only constellation where a directive has direct effect, can have direct effect, is in the vertical relationship between private parties and a public authority. Stichwort, example, here again, tax law. It's always a private party against the tax administration. If the directive on VAT, to stay in my example, there are many other examples, is badly transposed, then the judge will give direct effect to the very clear, precise, and unconditional provisions of the directive. It's vertical, the taxpayer against the tax administration, and will have to set aside, under Poplavsky II, the conflicting national rules, when there is a real conflict. On the contrary, if you have a case between a private employer and a worker, directives in the field of employment law, and the national law is contrary, what is then to happen? It's a directive on equal treatment. It's a horizontal relationship. How does that then play out? Primacy and direct effect. Poplavsky II. Should we then say, it has no direct effect because it's in a horizontal relationship? It's not a regulation, like GDPR, for instance, the privacy protection regulation, personal data protection regulation. It's a directive, no direct effect, and therefore the conflicting rule cannot be set aside. Let's forget about the directive. The answer, you feel it, is no. You don't have the obligation to set aside, but the primacy is always there to oblige the national court to interpret the national law as far as possible in compliance with the directive. So there is no direct effect in that the directive is not creating as such the rights. You need national implementation, but you can, of course, obtain the national implementation by interpreting the national law in view of the directive. And there is an extensive case law of our court stating that conform or consistent interpretation of national law with union law implies also the obligation, and that's maybe the most important thing I'm saying here today, the obligation, if need be, to change earlier case law, also by the Supreme Court of a member state, in order to have the national law comply with union law. That is to avoid the conflict. Then you avoid the conflict. The limit which our case law says is you should not go outright contra legem, because if you were to go outright contra legem, that would come down to setting aside, right? And you don't have to set aside because the rule of union law has no direct effect. So, let's try to sum that up. Consistent interpretation exists always as an obligation for all the rules of union law, whether they have direct effect or not. If they have direct effect in the relationship before you, very often for directives, a vertical relationship of a citizen or a business vis-à-vis a public party, then you have to set aside the rule. And you don't have even to make a big effort of consistent interpretation. You may, if you can do it, because if you don't find a consistent interpretation, you have to set aside anyway, because there is direct effect, Poplavsky II. If there is no direct effect, either because of the type of rule of union law involved, like a directive in litigation between private parties, or because the rule of union law is not sufficiently clear, precise, and unconditional, no direct effect, but still you can, as a judge, distill some meaning from the union law rule, which is part of your national legal system, then you have to interpret the national law in conformity, as far as you can, even while changing earlier case law, earlier jurisprudence. But you should not go, that's the limit, contra legem. What happens then if there is finally a conflict which you can't solve through consistent interpretation and the union law rule has no direct effect? Then there are only two ways to solve the conflict. That is either that the European Commission brings a case against the member state to have its law changed under an infringement action, or there might be a liability action brought in a first instance court against the public authorities because they have not implemented correctly a non-directly effective rule of union law. And indeed, for the liability of the public authorities of the member state, the liability to compensate the damage and the harm caused by their breaches of union law, the case law since Frankovic, 30 years ago, is absolutely clear that the rule of union law need not have direct effect. And that makes sense now, if you see what I mean, because it's the last outlet possible if there is an unbridgeable conflict between national law and union law. In any event, since that landmark judgment Poplavsky II of June 2019, the court always specifies whether there is direct effect or not, even unasked, because we know that that is now the trigger for the obligation to set aside. And we have, for instance, held a number of articles of the Charter of Fundamental Rights to have direct effect, such as Article 21, the non-discrimination provision, or Article 31, second paragraph, which is the social fundamental right to paid annual leave. We have also said it for the right to an effective judicial protection, Article 47. So when a case is presented to us, we rule on the substantive interpretation of that rule, but also indicating whether it has direct effect or not, or in what constellation, like horizontal or vertical, what I just said for directives, so that the national courts know exactly how the rules come in the national legal system. I refer now to an excellent article which I came across in my research for this speech, an article written by President Varga András. It's a fantastic article. It's absolutely. It's Ostovic. It's also a judge here. Is in the room. It's a fantastic article. So I found it in the Hungarian Yearbook of International and European Law, an article of 2020, where you quote, and it's totally the article is entitled "National Courts and the Enforcement of EU Law, Hungarian Experiences." That's the title of the article. So I gave you the quote. National courts play a key role in enforcing rights and obligations under EU law, so that the application of EU law remains uniform in all the member states in compliance with the jurisprudence of the Court of Justice of the European Union. I couldn't agree more. That is exactly what I just here intuitively have brought to the fore. So union law is part of national law. We should stop looking at union law as something foreign. Union law is Belgian law. I'm a Belgian. Union law is Hungarian law. Union law is Portuguese law. And I can say it 27 times. It is a sort of a layer of legal rules which is common to 27 states. It's just as much Hungarian as Belgian, as Dutch, as Irish, as Estonian, Polish. It's common to all of us. It's our common legal heritage. And we have to know how to deal with it, so that these rules, which the member states, as the masters of the European Union treaties, have thought important to have them in common. That is union law. And so the primacy of union law is a rule, is a means, an instrument to settle possible conflicts. Normally, it is solved through consistent interpretation, which is a conflict-avoiding strategy, right? Because if you arrive to consistently interpret all the rules, that is exactly the bridge function about which you spoke so clearly. I couldn't agree more there as well. It's really this bridge function. You integrate the national tradition with these European rules and make a single interpretation. If you doubt about something, then you refer to the Court of Justice. So that is how it works. And if all of that conflict-avoiding strategy is not working, then you have to look precisely. Is the rule of union law a rule having direct effect, clear, precise, unconditional, and in a litigational setting where direct effect is possible? I add this latter thing in order to exclude the horizontal direct effect of directives and to make the distinction between directives and regulations. Then, if it has direct effect, you must set aside the conflicting rule. So that is the state of play in general for the conundrum primacy, direct effect, consistent interpretation. Now, as already said also in the excellent article, and I refer to it myself as well, the preliminary ruling mechanism is a very important mechanism in order to have the definitive interpretation common to all 27 states of the common rules. That is why this procedure exists. The Court of Justice is not smarter than the Kúria with K here in Hungary. We are not smarter. We are judges just like you are judges. We are judges of a last instance court. That's true. There is no further appeal. That's the same here. What's then the difference? Why do we need a Court of Justice to interpret union law? Well, it's almost bumping into an open door, of course. But union law is the law common to 27 states. It exists in 24 languages, which are equally authentic. A national court cannot have access to 27 legal systems, 24 languages, etc. The Court of Justice has been created by the member states as masters of the treaties to have a jurisdiction which can deal with the diversity of national legal systems, of national languages, of terminology, and to come to a common law type of interpretation of the common rules. And all the member states are authorized to take part in the procedure. So it's not a matter of a beauty contest, who are the better judges. No, it's simply a different role. The role, and President Varga has just brilliantly clarified it, the role of the Kúria here is to have the uniformity and the consistency of all the law applied here in Hungary. And he does it remarkably, as we all know. That's why I'm so proud to be here today. We must do, mutatis mutandis, the same at the level of the European Union. For the rules which the member states have decided to have the Union make these rules, like the European Parliament and the Council and the legislative procedure and the rules being made, and then these rules must not only be common on the books, but they must also remain common in their interpretation, application, and enforcement of these rules. That's quite clear. Again, pacta sunt servanda in the sense, otherwise the whole objective of the Union is falling apart. Now, the preliminary reference procedure is absolutely key. And it rests on the following paradigm. And we explain that in a very important judgment, which is very well known here. That is the IS judgment of November 2021. The illegality of an order for reference. It's a judgment where the Kúria had, as you know, in the interest of the law, said that a reference by a lower court to our court was not necessary and that it could not serve the objective to possibly bring to light a conflict between Hungarian law, national law, and union law. With respect, and we are here among friends, that was, of course, ill-focused, because since Van Gent and Loos, which the court in its judgment Grand Chamber of November 2021 quoted in full, just a literal quote of a judgment of the 5th of February 1963, our predecessors, now over 60 years ago, already said that the purpose of the preliminary reference is precisely that the courts in their independence from the legislative and the executive inside a state, that the courts in their independence can possibly discover a conflict between national law and union law, and in order to have certainty as to the right understanding of union law, they refer, and the lower courts may refer, and nothing hierarchically in the judiciary or in other processes can hinder the lower courts to make such a reference. So the right to make a reference cannot be limited by any judicial or legislative or other type of political procedure. So it is the autonomy of the first instance court, of the appellate court, and of course the Supreme Court is obliged to refer. And we quoted effectively in that judgment, referring to Van Gent and Loos, but it's very rare. For once, we quoted between quotation mark the seminal initial judgment, the vigilance of individuals concerned, that is the litigants before the national judge, to protect their rights, amounts to an effective supervision, in addition to the supervision entrusted by Articles now 258, 259 TFEU, that is the infringement actions brought by the Commission or a Member State, to the diligence of the Commission and the Member States. Limitations on the exercise by national courts of the jurisdiction conferred on them by Article 267 TFEU would have the effect of restricting the effective judicial protection of the rights which individuals derive from union law. So that is the literal quote. We only replaced the articles of the treaty because at the time it was, of course, the EEC treaty. We just put in the articles of the TFEU, but it's not us having written that. That's our predecessors who, unfortunately, none of them is still of this world, in 1963. So it's really foundational for the European legal order. But this brings me to a further point, which is very, very important. And I think I say it since now the 9 years that I am in this responsibility. I say it in all the member states, because I'm constantly in fora like this one, in all the member states, not just here, but also in Portugal, in Spain, in Paris, in Germany, everywhere. When I have these audiences of the Supreme Courts, and in many member states that is to be understood plural, think about Germany with all the specialized Supreme Courts, it brings me to Cilfit, Cartesio, also Consortio Italian Management. There is now a further case pending, Kúria, which came to us from the Slovenian Supreme Court, Kúria, K-U-B-E-R-A, Kúria. The judgment will be there for October again, I think. It's this duty to refer by the highest courts. At the risk of surprising you, is this really a duty? An obligation? Why would we not see this for the Supreme Courts as an opportunity? Because, take this IS case. I understand that the Kúria, okay, as a Supreme Court of Hungary, has somehow been, I say this now intellectually speaking, frustrated by a reference made by a first instance court, which may have incorrectly presented national law as the context in which an interpretation of union law is asked. But the best way to avoid this is to proactively seize as an opportunity every occasion which presents itself to yourself as a Supreme Court to make the references. And we see now in a number of member states, I told you over the past 9 years, there is an enormous development. Take a member state as Spain. Big member states, one of the 5 biggest member states. In the last year, we got over half of the almost 40 references from Spain from the Tribunal Supremo. 6-7 years ago, it was 2 or 3 a year. But now they have totally integrated this. If there is a slightest doubt, they refer. Because they know if they do it, the lower courts will follow their judgment, which integrates our judgment. And it immediately creates the legal certainty. And we also win, frankly speaking. I say it among friends, because then we have the interpretation of the national law, which is, we don't interpret the national law, but the national law is the context in which the question of union law arises. If it is a Supreme Court referring to us, then we know that it is the national law authoritatively and correctly stated in the order for reference, which is an enormous comfort for us. Very numerous, unfortunately, are the cases from all over Europe, not specifically here Hungary, certainly not even, where a first instance court refers, and then the parties in the main action, or even the government of the member state concerned says, yes, but the judge got it all wrong. And of course, we can't pronounce on national law, so we must, in principle, give our answer starting from the premises and from the context in which the questions are asked in the order for reference. If it is a Supreme Court referring, you never have such a debate. There is no government which will contradict the reading of the national law when the reference stems from the Supreme Court or the Supreme Administrative Court or sometimes the Constitutional Court. I think of Belgium and Austria, Italy also, where the Constitutional Court makes many references. So that is a very important thing. So that is why I'm saying don't be too restrictive. It's an opportunity for the Kúria. And also at national level, it makes its contribution. And I say this also in the light of the global ink trade case, to which I shall now come, but almost as a closure of the remarks, so that we still have the time to answer some questions also. The global ink trade case, and now I must stay a little bit closer to the text because it's a technical case. It's a VAT case in which the Hungarian tax authorities refused to company the benefit of the right to deduct VAT appearing in invoices relating to the purchase of office supplies. The tax authorities took the view that the company concerned had not acted with due diligence, since it had failed to obtain sufficient information about the true identity of its supplier, an undertaking which did not carry on real economic activity and did not comply with its obligations. But according to the referring court, which was a lower instance court, the first instance court, that level of diligence which imposes on all taxable persons the obligation to carry out complex and far-reaching checks on suppliers, it was certainly in keeping with case law of the Kúrián, but that court said that in its opinion it was at odds with orders of the Court of Justice in case Vikingo, Fővállal, Koso and Kruprint, which do not require such checks. You know, in VAT, and I'm somewhat hesitant saying that with the biggest expert on the matter here in front of me, but the right to deduct is a quite absolute right, and when it is denied for reasons of fraud, it is really very restrictive in terms of establishing this fraud. Whatever, that's the content. So the referring court said, in fact, to us, a first instance court, my highest national court, the Kúria, got it wrong in terms of the case law of the Court of Justice. And so they refer. First of all, it is vested case law of the Court of Justice, also since decades, that the lower courts, I said it already, since the Rijnmühlen case, 1974, have, I told you, the unimpeded right to refer to union law, to refer to the Court of Justice on matters of union law. So, in other words, this first instance court is perfectly entitled, directly on the basis of Article 267 of the TFEU, to say, I disagree with the Kúria. Not on a matter of Hungarian law, there the relationship is governed by national law. They're bound by the jurisprudence of the Kúria on matters of Hungarian law. They are not bound by the Kúria jurisprudence on matters of union law. They can always refer. That's one. That is case law of 50 years old since the Rijnmühlen case, January 1974. And that is precisely, in fact, to force the Supreme Courts to comply with their obligation to refer. Because if they don't refer, whereas they should have referred, there will always be a lower court saying, no, that's not right. And this is happening in all the member states. So, no, I insist. I gave now this Hungarian example because I was asked to do so. But I would have had no difficulty to take a Belgian example, a Dutch example, a German example. It happens all the time in all the member states. That lower courts say, I'm not in agreement with the case law of the Supreme Court on a matter of union law, but, and now the essential point comes, the case law of the Supreme Court established without previously having referred the matter to the Court of Justice to obtain an interpretation of union law. And here you see the point. So the Supreme Courts avoid this uneasy, because it is an uneasy point, in the relationship, hierarchical relationship between lower courts and Supreme Court. You can, in German you would say vorbeugen. You can sort of avoid, prevent that risk from occurring by yourself referring, because the Supreme Court, the National Supreme Court, normally knows the case law of the Court of Justice rather well. They have study services to study union law, far more than the lower courts, and reference was made to it. It's also the case here. So when there is the slightest doubt, you refer. Thereby, your decision will integrate the interpretation of union law, and then, of course, once the Supreme Court decision integrates the decision of the Court of Justice, then the lower courts are bound. And I shall tell you, you'll ask me, can they then still make a reference? The answer is yes, they can. And you know what our answer then is? A short order, without even notifying the case to the member states. It comes back, as they say in French, par retour du courrier, where we repeat the earlier judgment. So the matter is then closed. So yes, and it appears from the Consortio judgment, Consortio Italian Management, where we have for the first time made a distinction between Supreme Courts and lower courts. This is deliberate. We say if a Supreme Court has a doubt because there is sort of difference in the case law, the lower case law of other, the slightest doubt, should refer. Once we have said the law, that law is binding because the Supreme Court integrates the Court of Justice's answer in line with the excellent article I just quoted. And for the whole legal order, you have inside the country the uniformity of the law. That's exactly the function of the Kúria of which President Varga spoke and which I share completely. Now, we have had such cases of other member states. We have had a recent Belgian case where the Constitutional Court of Belgium got it totally wrong and had disregarded a case, a judgment of our court, and there is a first instance court in Ghent saying, yes, but this is totally wrong. I'm not bound by this judgment of the Constitutional Court on the point of union law. And of course, we didn't even send this to the Grand Chamber. This is a chamber of 3 judges, repeated the earlier judgment and said that this was binding on the Constitutional Court and on all the courts of Belgium and of all the other member states. So it's really the integrated practice. We have had the Bulgarian case Elchinov in 2010. We have had the Krishan case with Slovakia. We recently had the Link case vis-à-vis Romania. There are many examples of this sort. So I think with that, we have to see that references made by the Supreme Courts of our member states, and by Supreme I mean Supreme Courts. I know for Hungary it doesn't play because it's a single Supreme Court and then a Constitutional Court, but in many member states it's the General Supreme Court, the Administrative Supreme Court, and the Constitutional Court. So we have a privileged relationship because these courts are definitively stating national law. So for us it's a comfortable setting because we know without a dispute possible what a national law is. That gives us the framework to see how union law interacts fluently and consistently, also in a view of conflict avoidance, with this national law. And once we say the union law, the Supreme Court integrating that union law, interpreted by us, it also puts to an end all legal uncertainty in the judicial hierarchy of the member state. So that is why I'm saying the obligation to refer for Supreme Courts, no, it's an opportunity to refer and to fully play its role as a national constitutional court. And sometimes the answer which a Court of Justice gives will be also for a Supreme Court in the form of an order. Because the Supreme Courts, and also that might surprise you, but if you put a question as a Supreme Court, please also suggest an answer. Also suggest an answer. I told you, the national constitutional courts, the national Supreme Courts, our court, we are judges of equal learning. There is no hierarchy. That's why I took issue with the preeminence terminology. There is no preeminence. Not of norms, not of judges, not of nothing. It's a collegiate work. It's a network. So that you interpret how you would do it, but then you say, well, but there are 27 systems, there are 24 languages, we don't have, of course, TUGRIF, we can't integrate it all. There is also a possibility to look at this interpretation differently, and you refer. Why is that so important? That you also give, with the question, your own proposal of an answer. Well, the reason is the following. Once a reference for a preliminary ruling comes in our court, the first thing which happens is it is being translated in the 24 official languages. So the Kúria reference on consumer protection exists now in all 24 languages. I read your judgment in Dutch, and it's on the website. We publish all these translations. So by making a reference as a Supreme Court, you sort of radiate in the whole of Europe. You open, as the taker of the initiative, a pan-European debate. If you give with the question your initial feeling of what might be the right answer, that is a proposal of interpretation, all the member states which come in, they will position themselves vis-à-vis that reasoning. And very often they will say, yes, well, that makes a lot of sense, also with us, which is crucially important for us, because we sometimes have to make a synthesis. So national courts do not ask a question to the Court of Justice like a student asks some further explanation after the professor has ended the class. Now, we're here among friends, I say it openly. That's not the type of conversation we have, right? So we are judges of equal learning. We really want almost like the deliberation processes within the Court of Justice itself, where we constantly explain legal rules and principles of the different systems, and we come to a synthesis in our collegiate judgments without a possibility of dissenting or concurring opinions. It's the same type of relationship between national courts referring and our court. So we really want to know what you think about the substance of the question you submit to us. The debate will be based on that starting point, and then, in our judgment, when we follow the national proposal, then we say openly why we agree. If we don't agree with don't agree, if we sort of take in nuances, it's mostly a question of nuances of maybe surrounding limitations and conditions of interpretation, then it will be very transparently explained, but in extremely respectful and collegiate terms. That is why we speak now more and more, and it's not just a loose terminology, about a dialogue. The dialogue is really when we can take in substantive standpoints. All the other member states come in, you have a pan-European debate. When the question is important, it's all reflected in the reasoning. And if your proposal of answer is being followed, it might even be that you get a very short order, where we validate, we say, yes, that's indeed the answer, it is absolutely clear. And that is not a blame for the court. Please do not think then, oh, but in that case I should not have asked. No, you should have asked. Because the fact that we confirm it in an order means that your interpretation is now valid, not just in Hungary, but in the 27 member states, in the 26 other member states. So what you in fact do with the reference procedure is to enlarge, to broaden the geographical scope of your work in Europe as a whole. And a Supreme Court, the Constitutional Court, has a responsibility as part of the network of courts, Europe-wide. So in that sense, the Court of Justice of the European Union needs you and needs all your colleague courts in the other member states to engage that dialogue and to enrich the development of European Union law. I think with that, the main message is given. If you have further questions, I know there is Chilfit and Consortio, and when you don't refer, you have to reason and so on. But I would, that you have read, I can of course answer questions in that part, but I think my main message is to say we are together in this. Primacy, direct effect, starts with the interpretation of the rules of union law, we indicating whether it is directly effective or not. That triggers then this obligation to set aside or not. Consistent interpretation is always valid because of primacy. When the Supreme Courts take the initiative of a reference, you avoid problems like this global ink trade case. It's an opportunity to refer. You can do it by giving your own views on the matter, and when getting the answer back, you are playing your role in the network of European Supreme and Constitutional Courts, and you also strengthen the judicial hierarchy, because if you don't play the game as a Supreme Court, then you are sort of overtaken in speed by lower courts, and that, yeah, that's how the system is construed, but it's not how the system, ideally speaking, should function. And that's only in your hands. Thank you very much.